Hi folks, you're with Tacitus today. Tacitus today, your pushback channel. Thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about something that I think should be an international headline. And not for the first time, a judge in making a particular judgment in a court of law between two litigants has made the utterance, has openly stated it. It's not like they're hiding it. But the judge has said that because the social power, remember, social power is ideological. No one agrees. It's not a factual thing that you can test or check for or measure. That the social power between the litigants is equal. They have equal social power, says the judge. And because they have equal social power, so claims the judge can then rely on facts and evidence to make a determination in the case. The converse is that if the social power between litigants is different, that takes precedence in the legal decision making. So if one's a straight white guy in a legal contest with the proverbial black lesbian, then the black lesbian has all the advantages in order to compensate for her supposed lack of social power and to counteract the alleged large amount of social power the straight white male has. Now, again, there's no clear definition or precise definition or measurement of what social power is. The black lesbian may be an online influencer and very rich. The straight white guy may be a street bum living off scraps. Like how do you actually measure this social power, given that it's by skin color and sexuality and so on? Now, the judge went on to in this particular case, but there have been others, and I'll come to that in a minute, to say, well, these people have equal social power. It turned out to be two white lesbians, both in working for a government department in the same sort of job and this sort of thing, and they bought some sort of investment property together, but one was claiming that they were entitled to a bigger share or something like that. That was the basis, and was taking it to court. But the judge saying, no, I'm going to rely on the facts here. You're both lesbians, you're both white, your social power is the same, and therefore I can rely on the facts. Now, that's in my view, that's monstrous, because what it means is judges can and do, and it's all over the Western world, whether it's in the United States, with the activist judges trying to disrupt and frustrate the policies of the Trump administration. The Trump administration represents, white, straight male social power. Everyone else represents some sort of minority group. So they have to make decisions based on that social power differential as they see it. But there's no legal framing for that. So my concern, over a number of years now has been, well, if you want to use the social power argument to determine legal outcomes and so on, then you need to clearly define it. What precisely is social power? It needs to be something that's read out in the court. It needs to be codified in law by the lawmakers in the Congress and the Senate and the House of Representatives. It needs all that sort of stuff in order to make it clear. The West has had something that really few other countries have had, which is codified law, and codified law that applies equally to everybody. Not that other societies haven't tried it, not that there aren't certain subsections where it may be applied, but the idea that everyone is equal before the law made the West a great place to do business. And if you wanted to own property and keep your money, and so the government wasn't taking it from you, then the West was the place to go with their clearly codified laws. And England as a place has had a very long tradition of codified laws in all sorts of ways. Given that the aristocrats would own large tracts of land, it could take a small plot farmer hours to get to the market to sell his his apples or his corn or his wheat or something. So that there was a system what were called public footpaths, so you could actually walk across the aristocrats' land in the shortest distance it would take to get to the village or the town. And these were protected by law and these sorts of things. I mean, that's a small example, but the idea of a codified law that everybody abided by meant that society was stable, had a lot of continuity, and social trust was high, and so on. And so people were prepared to take risks to accumulate wealth, knowing that you'd be protected by law. Now, once you have something coming along, as in social power, that is not codified, it's imposed, and it plays a huge role in legal, in the law, in the court battles and litigation and legal disputes. It creates a huge role, but it's not codified. It's not clearly codified. It's not specifically stated. It's not written into absolute law by the legislatures. And this means it's an arbitrary, random device that judges, depending on their own activism and attitudes to it, can use arbitrarily whenever they choose. And if you happen to be in a legal contest with someone who has a lot less social power than you do, then it's almost inevitable now that you're going to pull an activist judge, and that activist judge will decide in favour of the other. And just to give you simple little examples here, two neighbours in a dispute over the fence line. the neighbour with the least money has decided they just want to go ahead and have a particular fence, and they did it without the approval of the wealthier neighbour. The wealthier neighbour complained, said, well, I'm not going to pay for that extra amount. So the poorer neighbour decided to take it to court. And the judge in the case looked at the wealthier man and said, well, you look like you've got plenty of money. Why don't you just pay it? So what? So what if the other guy broke the law? So what if he broke the contract? So what if the other guy, he's got less social power than you? So just you pay the difference, and by the way, you're going to have to wear the court costs in this too. Unbelievable. So this is a judge's attitude to social power. This is why lawyers now frequently advise their clients to, for goodness sake, don't have a haircut, don't have a shave, don't wear a suit, don't wear nice clothes that are cleanly pressed or something. Wear the Walmart well worn, well used, holes in it Walmart clothing when you go. Don't have a shave, don't have your hair cut, and so on. Look like a bum, and therefore the judge won't say, well, look at all the social power you got. You're well dressed and looking very respectable. You've got all the social power, so I'll make a decision against you. Now, this is not the first time I've seen these proclamations by judges, but there's no outrage. There's no politicians screaming and frothing going, judges are not abiding by the law. The law. Judges are not abiding. They're just making it up as they go along. They're just ideological fanatics and da-da-da. No one's saying it. You don't hear that anywhere. I can't find a single article about, just recently in the United States, there's a kerfuffle given the very coordinated use of activist leftist judges to frustrate the Trump administration. But outside of that, in other countries, whether it be Britain or Australia or Canada, New Zealand, these sorts of things at various levels, not big ticket stuff, at various levels, and judges saying, you got the same social power, I can just make the decision based on the evidence. Whereas if the social power is not the same in the eyes of the activist judge, so it's arbitrary, it's not codified, remember, not codified, and this is the issue here. The judge can just go, you've got more social power, I'll decide against you. Or you've got less social power, I'll decide in your favour. And the facts and the evidence are irrelevant. So this is something that the amount of new ways of looking at things, doing things, of things that are believed in, cultural stuff, is being imposed on our behaviours, imposed on our interactions, imposed on our societies, but none of it's codified. And this is now the issue. Now, if they want to have social justice stuff in courts, as part of codified law, then let's look at that. And that will then be a clear, and the judges then will have to stay with that framing, given that it's the codified law. But it's not increasingly activist judges are being put in these judicial roles and then given wide-ranging discretionary powers where they can just arbitrarily and unilaterally use their activism to decide legal outcomes, and thus redress the imbalance of centuries past, and restorative justice, all these sorts of things that are, of course, themselves not codified and just live in the delusional minds of the activists. You've been with Tacitus today, your Pushback channel. Thank you for listening.